let me ask you one more time, and this is off what we're going to talk about, but the Freddie Mae Freddie Mac is a standardized federal form. That's not mandatory, but it's needed. I'm asking a question.
Yes.
That is the answer. So it's also, it's not mandatory yet. We're not talking about this. We're talking you and me. It's not mandatory yet. And I think it will become mandatory.
So it's not mandatory yet.
But they're changing it, right? It's changing.
Information, yeah, the information that is on there, as far as they're concerned, it is mandatory for their underwriting for them to purchase a loan.
Lenders. The lenders are saying our form trumps, not mandatory. None of this is mandatory, but our form trumps federal form. And we're saying, no. First of all, there's nothing mandatory says you have to do this. Not yet, not until we make somewhere along the way, someone's going to say, well, they legally don't really have to do it at all.
Right.
Now, underwriting might say, we want it or we're not approving the loan. Okay.
Right.
But they're not saying we have to have Bank of America's, Wells Fargo. We have to have Wells Fargo. So the point we're trying to make, maybe we're making, I see we're recording. The point we're trying to make is there's nothing that says you must do this until it does. And when it does, this form will not be what it started. The reason why, in my opinion, it will be made mandatory is because it does all these things that the lenders want it to do. Well, they're going to spend the next 2, 3, 4 years lobbying to make it closer to the forms they want. I don't care why anymore, because that will become mandatory, which means everyone will have to order this form. That's standard, but the form would have been made standard with 100 new questions on it. But I'm fine with standard because it makes our job easier for our client, as opposed to making our job more complicated because we have 5,000 individual forms that represent all these banks and mortgage companies.
So my point on this is, you have our competitor who has 5,000 forms that go for every bank and lending company. That's all really well for that particular bank or lending company. The bottom line is this: when they go to resell that loan, what they need, the information they need to resell that loan, and you know that like most of the loans in America they don't make a loan and then hold on to it. They make a loan and then sell it, right? So when they sell that loan, in order for that loan to be purchased by Fannie Mae or Freddie Mac, it has to meet the guidelines that are on the Fannie Mae Freddie Mac form, which is the one that we're saying this is the form you should use. So what we're doing basically is we're skipping the middleman. We're saying, the middleman doesn't really, their underwriting guidelines aren't enough even to meet the Fannie Mae Freddie Mac.
We do talk about this in another video that we have done. Is it what's the title of that?
The 22 lender questionnaire 22 update, 2022 updates. Yeah, the truth about lender questionnaires. That was an article that I wrote about 3 or 4 years ago. And we've been on this bandwagon for a long time. So
it seems like our competitor seems to enable or facilitate, and their background is lending. So they would automatically fold into, let's make it easy for the lenders. And that means that they're telling their managers, you must fill this out. And we have an insurance and real estate background, which is influencing us looking at it from a more like, do you even have to fill this out? And ultimately, everyone says no. There's no law that says you must. And until there is, you really don't. They need it to probably sell in the secondary market. So they do need the Fannie Mae Freddie Mac form.
Yes.
I do believe it's like they need it, but they don't need those other. It's like they take it and I'll say bastardized. They change it so much that it becomes something different. And we look at it as way more of a libelous situation, which we go into more detail on that other, which will be a link to this video where you can go see the detail on that. But that's less a philosophy and more like the real life practicality of don't fill out these forms because they make you more money. don't fill out these forms because they present you liability for the future when and if we have another 2007 to 2013 dip in the market and everyone's looking for someone to blame.
Right.
You would have signed your name to information that you either know or don't know, and in most instances don't, but you're trying to facilitate this. There's a libelous situation that you're opening yourself up to.
Yeah. And I think um, there's so many legal ramifications that can come out of that, and signing those and filling out those lender questionnaires and signing those things. It's crazy.
And we
Uh,
do believe that if you absolutely don't know an answer, you should be honest and say you don't know it. I don't think you should try to answer it, number one, the way you think they need it answered, or try to answer it
oh,
because you don't
yeah.
know, but you think I should put an answer, and that you should just probably just say I don't know to a lot of those.
So we're the topic today. The topic that we're talking about is really staying on best practices, right? So I'm going to
Yes.
say for me, I think best practices for a management company is to only use the Fannie Mae Freddie Mac 1076 476. It's called Fannie Mae 1076 Freddie Mac 476. Only use that form, number one, because that's the form that 90% of the loans that are issued are going to be resold. They're going to go into that marketplace. That's the form that they need. Okay, that's number one. Number two is management company employees don't try to fill out this form by yourself, right? My suggestion is go to the board meeting, get the attorney for the association, go to the board meeting, and fill out that form together, right? Like you said, Joe, if you don't know the answer to a question, don't fill it out. Go to the board. Let the board talk about it. And you know what? Some of the answers are not tracked. Oh well, what's the percentage of this? We don't track that. What's the number of those? We don't track that. So there's certain things that you can do there that are going to do that. So I'm going to say number one, only fill out that one form. Number two, get the management or get the attorney and the board members of that association involved and filling out that form. That also limits your liability, management company, as when that form goes out, you can say, look, the board filled this out with the blessing of the attorney. Not, it's not you or your employees that filled it out.
How practical that's a great process to cover your buttocks
Right.
because you're spreading the liability. You had a documented with the attorney there, and you paid them.
Yeah,
And if you have 40 HOAs, we're recommending you do this 40 times.
absolutely.
And you've done it once, so you got the answers for all of them. In each HOA, you've answered the
Right.
questions with, and you've shared in a way. What is the insurance for the directors? Is it DO? What is it
DNO,
called?
directors and officers.
DNO.
Yeah.
DNO. Well, they've got the insurance policy, and if you've technically, I think if you had the meeting formally in a board meeting, and you had this attorney there, and you paid him, and he gave you legal, you're on the sideline. The attorney gave the board legal advice. You catalyzed this. You made this happen, but you stepped aside, and you do not. I'm not an attorney, but I feel you've spread your liability to the attorney, which you're paying. The HOA is paying that, and you're sidestepping the responsibility that you take every time you fill this out. So
Right.
really, it should be a 2-3 hour, $1,000 to the attorney. Fill it out once with the board. You got to do it 40 times. This is probably the proper way to deal with these lender questionnaires, and a lot of companies won't. What do you think? Do you think a lot of companies would do this?
I think that a lot of companies aren't doing this. They haven't done it in the past, and that's why this is the drum that we're beating now, and we're hoping that this can become the way that it's done. By the way, you can charge. There's no regulation. We talked earlier about
Oh, you get to charge as much as you want?
yeah, we charged. We talked earlier about state laws, and I'll tell you what. To the best of my knowledge, and every attorney I've talked to across the country, there are no laws that have anything to do with lender questionnaires. Whether it says you have to fill it out, you don't have to fill it out, but you can charge nothing. So let me say this: when you take the board, you take the attorney, and you get the board members. Like you mentioned, there's a cost involved with that. Charge the appropriate fee to cover the cost, right? Charge for that document. Now, I'm not saying charge $1,000 for the document, but you can
But
charge.
why not? But why not?
You know what? You could, Um, I would say the answer to your question is why not? Is because you're definitely going to force regulation if you start charging ridiculously, absorbently, you're going to force regulation.
I'm
I'm
fine with that.
saying if you charge a couple $100 for each one, right? So now you've spent $1,000, and then after five or six, you've made your money back. I think that's appropriate, but charge
Yeah,
for it.
yeah.
You know,
And I also think what we're talking about is really don't. A lot of managers we see run around with their heads chopped off, and they're trying to facilitate the deal. They don't want it to fall out. They're being not threatened, but they're alluding to you're getting in the way of the deal, and you don't want to do that to your homeowner. And the pressure is like to perform, but really they're performing for the buyer, and they have no fiduciary to the buyer. They own the buyer nothing. They owe the owner. Now the owner could go get whatever it is that the buyer needs to fulfill their contract. That would remove liability from the manager and the processors. To me, I'm looking at removing liability to my client. I
right?
don't care if you do something specific in your process. Don't do the lender questionnaires that are specific. I would just never do them. And if you do them, we're saying do the long process, which is you got one, you tell them, oh, I'm going to have a special meeting with the board on this one. We'll get it to you in 10 days. You charge accordingly. You get that going. You do that 40 times, you got 40 HOAs. 100 times, you got 100 HOAs. And you've done it. Now, I don't know. Do you do it every year?
Yeah,
Things change. Maybe you have to do it with frequency, and there's your cost. So maybe it's a couple of thousand. You take consideration your time. The attorney is going to charge the HOA. So you take care of that. You removed your liability, and you have a process in place that every year around the same time, you're going to ask these questions again. You're going to have the attorney there again, and you're going to have a process when the crap hits the fan and you're being taken to court going, why are you doing this? You can say, I did this stuff, or I tapped into this process with this company and they told me never to fill them out, so I didn't. So your name is not attached to incorrect information, which will be twisted into, why did you lie about this?
right.
What did you know and when did you
So,
know it?
and let me just go with the alternative, the opposite of what you're suggesting is what our competitors are doing. Is our competitors are filling out that
Oh,
they're filling out those forms based
yeah.
on a certain set of questions that the management company answered, and they're answering them to the best of their knowledge and their ability. Which, by the way, they're not licensed or anything like that to interpret those things. So they're filling it out. But then here's what they do, Joe, is that they give it back to the management company. So someone in the management company has to overview it, right, or review it, and then their name goes on it. The management company name goes on it, not the document company.
Well, because they do have final eyeballs on it.
They
So
do have final
really,
eyeballs. They
they're the
do have
ones to sign off, right?
right. Absolutely. But how much effort? How much?
I wouldn't
Look,
sign off on that.
no way. How many times?
Yeah.
Think about this. How many times do we go onto a website and the website says, "Here's our terms," or we know that we want to get something, and it goes, "Here's our terms," and it's this long, and we just go, "Yes, I accept it," and move on. Right? We do that all the time. What do you think the manager or the person in the management company is doing? They get that thing back. It's 150 questions. You think they're going to read every one and research it and check it against the CC&Rs and do all those things that they need to do to make sure that it's right? They're not going to do that. No offense, management company owner. No offense to your employees, but they're not going to do that.
They shouldn't.
And so what they're going to do is they're going to go, yeah, I accept it, and then something's going to go out with information based on what the document company's employee interpreted to be for your association in your management company. Talk about shifting liability and accepting
Well,
liability that's not
we
yours.
already don't like the form.
I
Why
know.
would we like a third party filling out the form we don't like? It's just like adding more risk to the risky
Yeah.
situation. Yeah, yeah.
At
No,
least with the form that we're talking about, it's the same form. It's the same questions. It's the same now 8 pages. It was 6 before. It's the same 8 pages, right? At least we know what it is. When you get all these other custom forms, It's all those things plus whatever. You know, who knows what's in those things?
So talking about wrapping it up, talking
Yeah.
about processes, a process for custom lender forms is
Don't do it.
don't do them. You
Yeah.
just don't do
Yeah.
them. That's a
It,
great process. And
right.
I think it takes a little bit of backbone when you understand this the way we do, it's not us convincing you. It's you, the owner, thinking it through, going, really, there's no other reason for them to want, they didn't want this form before 2013.
Yeah.
They didn't want this form 2007 when the edge came and we all went
Well,
down there.
let's say this: they wanted them for condos back in the early 2000s, but they weren't as demanding and as crazy as they are now about
Well, and now
you
with that
have to
building
have.
that collapsed in Florida, now there's
Now it's
this.
even worse.
Well, even worse. It's got the fodder, whatever the word is. They got something to bite into now that's going to
Yes.
cause changes to the main forms. Once changing happens, they're going to add everything they can. And
Right.
my prediction is they're figuring this out. They're figuring out how they're changing the form so it takes care of liability. Once again, a
Right.
liability shift to buildings falling down. Well, what's the difference between that liability shift or we want to bundle them up and then sell them as securities? That's all wrong anyway. But now someone got stung. Someone got left holding the bag, and it was the banks. And the banks are now saying, we're not going to have that happen again. We're going to have people sign, and then individually, we're going to get our money back by suing, and their insurance companies will reimburse us.
Right.
Why else would they do this? Anyway, so we suggest do not fill these out and fill out what will become mandatory probably and necessary for each one of these loans to be bundled and sold at a secondary market.
And have the right people fill it out, which is the board members and the attorneys.
But really don't fill it out.
Yeah.
Just don't do it. Just don't do it. I think we have concluded this third part of the three-part series.
Yes, we have.
Very cool.
Cut.